And we're seeing tension in the system as the court is telling the executive branch what the law is and how to interpret it. And the executive branch, has pushed back.
A raid in a small Idaho town sparked a legal battle over due process in federal court. And we found it's one playing out in courtrooms across the nation. Tonight, why there's a surge in a legal tool called a habeas corpus petition, why federal judges keep ruling in favor of immigrants, and what it means for every American.
Protect and serve your community. Uphold your oath.
Last October, more than 200 federal, state, and local law enforcement descended on a horse racing arena in the quiet agricultural town of Wilder. The FBI executed a search warrant and said it was targeting 5 people accused of running an illegal gambling operation. But hundreds of others were detained in the process, with ICE ultimately taking more than 100 people into custody at La Catedral Arena. Many were Latino immigrants with deep roots here, pending immigration petitions, and U.S. citizen spouses and children.
That raid picked up more non-criminal individuals than I've ever seen picked up in any swoop in the entire time I've practiced law, because in the past, they used to detain people from jails, or they would detain people from their removal order hearing.
In the days and weeks that followed, immigration attorneys like Nikki Ramirez-Smith reached for one legal tool in federal court: habeas corpus petitions.
A habeas corpus petition as it relates to alien detainees would be the same as it relates to American detainees. It would be something challenging the lawfulness of a detention. It's a basic protection in the Constitution from unlawful detention.
The Wilder raid was not an isolated case. Attorneys across Idaho and the country are filing habeas petitions for people who've lived here for years. Like one man from Mexico. In the U.S. since 1997, no criminal record, picked up by ICE in December on his way to work in Caldwell and taken to the Elmore County Detention Center on an immigration hold. Nearly 19,000 of these petitions are pending across the country right now. Data from the U.S. District Court of Idaho shows 24 filed since the start of 2025. In the 5 years prior, there were 0. We tried to have people share their experiences publicly, but many said they were afraid to speak out.
We just find ourselves in court with every single individual person that's picked up, filing a new habeas, which then the judges have to review, they have to draft decisions. So I think it's just backlogging our courts with things that they could be better focused on, like prosecuting criminals.
For years, anyone detained by DHS inside the United States had the right to request a bond hearing. That changed last summer when the Trump administration issued a policy blocking anyone who entered the U.S. without authorization from being released on bond.
The government is claiming that it has the ability to keep removal detainees detained throughout the entire removal proceeding.
The Board of Immigration Appeals went further a couple months later, issuing the Hurtado decision, stripping immigration judges of the ability to hold these hearings entirely.
They determined that there was a different statute that applied, which generally in the past has only applied to individuals being detained at the border. And they tried to apply that same statute to everyone nationwide in the interior.
Without a bond hearing, the only path to release is a federal habeas petition.
Prior to this administration, I think I filed 1 in all the years that I practiced law in Idaho. Now we're filing them on a regular basis.
Winning a habeas case doesn't mean somebody gets to stay in the U.S. Their deportation case continues. It just means they have a chance to fight it while they're free, not locked up, potentially hundreds of miles away from family and their attorney.
It just prevents us as taxpayers from paying to detain them for however long it takes before the immigration courts can hear their petition.
Of roughly 20 petitions filed in Idaho's federal court last year, 14 have been granted so far. Out of the Wilder raid alone, Ramirez-Smith filed over 24 in Idaho and other states where clients were transferred, and says judges granted every single one. Earlier this month, a federal judge in California went even further, vacating the Hurtado ruling and ordering ICE and immigration courts to immediately inform detainees of their right to a bond hearing. The judge called their refusal a, quote, campaign of illegal action and a direct assault on on the separation of powers.
Now that that has been vacated by this California decision, we should see immigration judges giving those individual bond hearings to detainees as a default. But of course, there's going to be appeals. DHS is likely to push back and give other guidance. So we'll see how this all plays out.
Due process is fundamental to the Constitution. And without due process, none of us are protected. And I've had people say, well, I'm an American citizen, so I don't have to worry about it. Well, without due process, who are you going to prove that to?
Josh Hurwood, who is the former U.S. Attorney for the District of Idaho, expects the Trump administration to appeal the California judge's decision, potentially taking this fight all the way to the Supreme Court, potentially within the year. The U.S. Attorney's Office for the District of Idaho won't comment on this issue. But a Department of Homeland Security spokesperson sent me a statement saying the Trump administration is, quote, more than prepared to handle the legal caseload tied to the president's deportation agenda. DHS argues the Board of Immigration Appeals' previous ruling upholding detention without bond marks the end of what they call Biden's catch and release policies. They also say ICE, quote, has the law and the facts on its side and will continue enforcing this policy unless and until the Supreme Court shoots them down.